Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy, where we are continuing with our special series, evaluating documents, giving our opinions in the case styled as Idaho versus Kohberger. I'd like to do something a little bit different today. What I'd like you to do is to look at the docket itself and then look at a specific item. The docket for February 28th, 2023 includes a large number of items that were filed on that day, almost 40 of them. And every one, with the exception of the one that we're going to look at, the motion, is in order to temporarily seal something or other. So please take a look at the link that I provide in the description to this podcast. Then you will be able to go on the docket that is maintained by the Idaho courts and see what those items are, what all of those orders are. But the item that I would like to discuss today is the motion, which is an application for a court order. So the motion to temporarily seal the stipulation to release property and related documents pending hearing. This was filed by Ashley Jennings of the prosecutor's office. So this is the state of Idaho who is applying for this order. And unfortunately, we don't know who the stipulation is between, the parties to that stipulation, what property they entered this agreement about. The related documents, we also don't know what they are because none of them are described with any sort of specificity in this filing and anywhere else leading up to this filing of the 28th of February. But what's very compelling, in my opinion, is the reasons why she is giving here. The court should enter this order, she's stating, because if these items do not remain under temporary seal pending a hearing, the following will occur. And we know that because she's stating here, because release or disclosure would, number one, would interfere with enforcement proceedings. Number two, would deprive a person of a right to a fair trial. Number three, would constitute an unwarranted invasion of privacy. We don't know whose privacy she's talking about here because there are no further details given about which personal privacy is the concern over. Number four, disclose the identity of a confidential source, and or number five, disclose investigative techniques and procedures. Let's go back to number four. She's saying release or disclosure would, not may, not might, not could, but would disclose the identity of a confidential source. So, ladies and gentlemen, we now know that there is a confidential source in this case, perhaps a confidential informant or informants who has given information, who is working with the prosecution in this case, maybe who worked with the Moscow Police Department before the charges were even brought against Mr. Kohberger. But we do know that there is a confidential source because Ms. Jennings, as an officer of the court, would not state that these things, these bad effects would occur if she didn't have a good faith basis to bring them. So we don't at this time, at least as of February 28th, know what happened because this is the motion, this is the application for the order. I want to thank you at this time for joining us and hope that you will join us here again at the Indie Zone.